All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you. Welcome to the Court of Appeals. We're glad to be here in person today. I'm Judge Valerie Zachary. To my right is Judge John Airwood. To my left is Judge Allegra Collins. And I'm going to change my glasses so I can see. To your right is our court clerk, Jean Soar, and our court officer, Remillard. We have several things on the calendar this afternoon. The first is Rimmer versus Town of Chapel Hill et al. Are you all ready to begin? Okay, thank you. Good to see you, Judge.
Good to see you.
Let's begin.
May it please the court, my name is Christopher Brook, representing the plaintiff appellant in this matter, Daryl Rimmer. I'd like to introduce my co-counsel and colleague, Paul Smith, who's here with me today, as well as Travis Payne, who represents the amici who filed a brief in this case, the Police Benevolent Association, and the Professional Firefighters and Paramedics of North Carolina. Judge Zachary, I'd like to reserve 5 minutes for rebuttal. Daryl Rimmer worked for the Chapel Hill Fire for nearly a quarter century. He loved his job and being a go-to guy in his department. But during the course of his near quarter century on the job, he faced trauma day in and day out, and that took its toll. He developed severe PTSD based on cumulative workplace trauma in 2017. When he appreciated the gravity of his situation and that he could no longer do the work he loved, he timely informed the Chapel Hill Fire Department and timely filed the present case. This court accordingly must reverse the full commission's conclusion that Mr. Rimmer did not provide timely notice and did not timely file this claim. In the alternative, at the very least, this court must remand to the full commission to apply the governing case law in light of the fact, the uncontroverted fact, that defendants knew of all of Mr. Rimmer's medical treatment. The full commission held, and the defendants argued, that Mr. Rimmer's claim should be rejected because he was diagnosed with his current disabling condition in 2004 and did not provide timely notice of that diagnosis. I want to briefly walk through reasons why it's not correct.
Well, may I interrupt you quickly?
Yes.
Is there a difference between a PTSD diagnosis and someone suffering from subclinical PTSD or having Ptsd symptoms?
Yes, there is. First, the factual record makes plain that there's a difference. Dr. Artigues, the defendant's own expert in this instance, said that there is a substantial difference between subclinical PTSD, which would not support a diagnosis of PTSD, and sort of full-blown PTSD that Mr. Rimmer is suffering right now. There's also a legal difference there as well, because to trigger the notice requirements of 9722 and 9758, there needs to be, the severity of the diagnosis needs to be conveyed per this court's opinions, per the court's opinions in Singleton and May. The first reason why the full commission's holding and the defendant's arguments must be rejected is, sort of a corollary to the question that you just asked, Judge Zachary. Mr. Rimmer's current disabling condition is not the same as his 2004 condition.
I just want to stop for a second. I want to go, I think it's George Allen's deposition on page 39, and he was asked, and were you aware that he was diagnosed with depression and PTSD? And he says, yeah. How did you know that? He talked about it.
Yes.
Is that competent evidence to support a finding that he was in fact diagnosed with PTSD in 2004?
No, it's not, because it's clear from Mr. Allen's deposition that that is a report based on self-reporting.
And why isn't that sufficient? If he self-reports, that means he knows that he was diagnosed with it, and at that point, I mean, what else do you need?
Well, the case law makes very clear that what triggers the notice requirement is a diagnosis from a competent medical authority, not from a layperson. And we should be clear about what Mr. Rimmer was saying. It's sort of the way that I say that I've had the flu 8 million times. I've never had a diagnosis of a flu. I could have had a bad cold all of those times. What he says is, I know what PTSD is. For lack of better words, we, referring to firefighters, we use PTSD to talk about our troubles. This is, a colloquial sort of catch-all phrase. It's nothing like the requisite competent medical diagnosis that triggers the reporting requirements of 9722 and 9758.
But when we're looking at competent evidence to support, any competent evidence,
Yes.
any evidence, it's a really low bar.
Well, this is a jurisdictional fact, so competent evidence is not the standard of review. The standard of review is de novo. Whether there's been a diagnosis that triggers the notice and filing requirements goes to whether the full commission has jurisdiction. It's well established over the course of the case law in the appellate courts that those sorts of jurisdictional facts are reviewed de novo. So the finding that somehow this condition that he had in 2004 is the same as his current condition from the full commission is not accorded any deference by this court. But even if you disagree, and I think the Dowdy case lays it out best, that this is a jurisdictional fact that is reviewed de novo, but even if you disagree that that's the standard of review, a self-report is not a competent diagnosis from a medical authority that triggers notice requirements from 9722 and 9758. Rimmer's current disabling condition is just not the same as his 2004 condition. First, there's uncontroverted record evidence that they come from different origins. The 2004 condition relates to an injury by accident. It's caused by an injury by accident, caused by being struck in the head and neck while Mr. Rimmer was fighting a fire. The 2017 current condition that he has is an occupational disease caused by cumulative trauma. And the medical testimony is, it's consensus and very clear and all of accord. Ms. Azoy, Mr. Allen, who you referenced, Judge Collins, Dr. Sue, Dr. Artigues, all say that this is an occupational disease caused by cumulative trauma over the course of his 1995 to 2007 service with the fire department. None of them said that the current condition was caused by a discrete incident, by this 2002 injury by accident.
If it's cumulative, doesn't it accumulate through 2002 and 2004? So at some point in there, if he is diagnosed with PTSD, let's assume for argument's sake that he was diagnosed with PTSD in 2002, 2004. At that point, aren't we considering all the cumulative effects from when he started up through 2004?
No, Your Honor, because the records from Dr. Herkins and Dr. Benjamin, which are the only records that make any reference to PTSD that are in the record, are about the 2002 by accident. They are not talking about the 1995 to 2004 window, with the exception of the 2002 compensable injury by accident. So that's what those medical records are about. But again, even if there was a diagnosis of PTSD in 2004, and again, I do not believe that there was, what he was suffering in 2017 is different both in origin but also in symptoms. In the 2004 post-concussive syndrome that he suffered from, was diagnosed with, that was characterized by headaches, characterized by anxiety. The 2017 PTSD, full-blown PTSD that he was diagnosed with, characterized by intrusive thoughts of the terrible things that he had responded to as a first responder with the fire department, characterized by nightmares that kept him from sleeping more than an hour or two an evening, characterized by vomiting every day upon arriving at work. It's an entirely different order of magnitude. And it's uncontroverted and unsurprising that those different symptoms had different effects. In 2004, Mr. Rimmer never missed work due to psychological challenges. He never missed work until 2017. He continued to work for almost 14 years after this purported PTSD diagnosis in 2004. 2017, by way of contrast, is disabling. He could no longer work due to these psychological challenges. So the bottom line is that Mr. Rimmer's severe PTSD today is vastly different than the post-concussive syndrome he had in 2004. And when an employee has an occupational disease caused by cumulative trauma, the notice clock runs from the diagnosis of the occupational disease caused by that cumulative trauma, not one episode of that trauma, even if you were to lump the 2002 compensable injury by accident into the cumulative trauma bucket. That's what the Sellers case from this court teaches, that we assess timeliness by the diagnosis related to the cumulative trauma, not one specific episode. Second point that I want to make, Your Honors, the defendants had actual notice of Mr. Rimmer's injury by accident and all related medical treatment in 2002 to 2004. Mr. Rimmer was injured in 2002 when he was struck in the head and neck fighting a fire. He filed a claim. That claim was accepted. Mr. Rimmer executed a release allowing defendants access to all of his medical records. Defendants got all of Mr. Rimmer's medical records related to the compensable injury by accident, including the notes that I mentioned, Judge Collins, from Drs. Benjamin and Dr. Herfkins. The deputy commissioner found that the defendants had notice of this medical treatment, all of this medical treatment from 2002 to 2004. The full commission finds that somehow the defendants were in the dark about medical treatment, without ever explaining how that is the case. Indeed, the full commission made findings to the contrary, that the defendants had no knowledge of this 2004 medical treatment. It's uncontroverted by the record that they do. That alone is reason enough for this court to reverse the full commission's conclusions.
I don't think I understand the connection between them knowing about his treatment and his, let's say, purported failure to file for a compensable injury at that point. The onus is on the employee, correct?
That is correct, but what this court has held is that when, per the Yingling case and other cases, that when the employer has actual notice, that there does not have to be supplemental written notice. But in this case, there was written notice because he filed a claim related to what happened to him in 2002. He executed a release that made sure that he was sharing all of his medical records from 2002 to 2004.
So they have actual notice, but then the onus is on the employee then to actually file a claim within 2 years, correct?
There is onus on them to file a claim at that point. He'd already filed a claim that was accepted for this left arm injury where he had a slight permanent disability, but also for post-concussive syndrome. But again, it's entirely different than what he's suffering in 2017. He couldn't file notice of an occupational disease in 2004 because he had not been diagnosed with an occupational disease of PTSD based on cumulative trauma. And the third point is that even if you accept, Judge Collins, that Mr. Rimmer was diagnosed with his current condition, disabling condition, in 2004, which we contend he was not, and did not timely provide defendants written notice of this, which we contend he did, this is reasonably excused in these circumstances and caused the defendants no prejudice. Defendants were aware of all of his medical treatment in 2004. As I referenced, the Yingling case says that actual notice constitutes a reasonable excuse for not providing written notice. But again, we think he did in this instance. He did in this instance. Actual notice also allowed defendants to investigate and mitigate this claim and injury in the 2002 to 2004 window. They not only received all of his medical records, they also assigned a nurse case manager to monitor and direct his treatment. The nurse case manager assessed Mr. Rimmer as having resolving, quote, post-concussive headaches. Couldn't underline any more clearly how different the situation was in 2004 per the defendant's own nurse case manager and where we're at now. That's why the defendants cannot point to any evidence of prejudice in this record. They say they could have better directed his treatment, but they had a nurse case manager monitoring the case. If the treatment needed to change course or needed to continue, they were ideally situated for that.
But if he didn't file a claim for PTSD, then why would they direct treatment to remove him from a situation that might cause PTSD?
Because he was diagnosed with post-concussive syndrome. They were on notice in regards to that. There was clear notice that that there were notes that said it was possible that he had some PTSD symptoms. I don't think that it constitutes a clear conveyance of the severity of his circumstances necessary to trigger another filing requirement. But even if it did, even if you disagree, they knew about this, and if they knew that he needed further treatment, ideally situated to provide that treatment. And instead, they didn't provide any further treatment. They welcomed him back to work. They didn't welcome him back to work for 6 months, and then he tripped up again. Welcomed him back to work for 14 years, where he did not need any further psychological treatment. Defendants also say in their prejudice argument that they could have removed him from traumatic stimuli, but the nurse case manager did not deem that necessary. Moreover, there's no evidence in the record, none, and here the defendants bear the burden of a purely administrative job removed from traumatic stimuli with the Chapel Hill Fire Department. There's certainly no evidence that that sort of job was available during Mr. Rimmer's tenure with the fire department and that he was qualified to fill that role.
Let me ask a question. One reason, obviously, psychological injury is different is because we can't see it, so we can't assess when it's healed. How can we know when, for argument's sake, a PTSD diagnosis in 2004 ended and a new, I guess, diagnosis began? Is there any point at which we look at?
It's difficult, and that's why I think the case law is so exacting that there has to be this clear, direct diagnosis that conveys the severity here. In this instance, I would contend there are probably difficult instances where it's hard to draw a line between PTSD symptoms and then subsequent PTSD diagnosis. This is not that case. Every one of those psychological care providers, Ms. Azoy, Mr. Allen, Dr. Sue, Dr. Artigue, the defendant's own expert, said in this instance, this is a cumulative trauma that spans the entirety of his tenure, his 23 years with the Chapel Hill Fire Department. Indeed, he started developing a symptom of vomiting every day that he showed up to work after responding to a fire in 2017 at which 2 dogs were incinerated. And he was sort of haunted by that smell going forward and could not escape that smell. So the question is well taken. There can be cases where it's hard to draw the line. This is just not that case. There's a very clear line that the consensus testimony speaks to. Full Commission also, returning to prejudice, concludes that earlier therapeutic treatment could have mitigated Mr. Rimmer's current condition. There's no finding or record evidence to that effect. Defendants never even asked Dr. Sue or Dr. Artigue or Mr. Allen whether that was the case during the course of their depositions. The defendant's chief substantive response to these 3 points is to argue that the plaintiff's current claim is time-barred by North Carolina General Statute 9747, that he impermissibly is seeking further compensation related to his 2002 compensable injury by accident. But this argument has been waived, and even if you reach the merits on it, it's unavailing. In regards to waiver, the defendants never made this argument in front of the Deputy Commissioner. They never made this argument in front of the Full Commission. The first time they raised the argument is in the response brief to this court. That's not how that works. That argument is waived. To the merits, no medical practitioner who examined Mr. Rimmer again believes that his condition now is the same as his post-concussive syndrome he experienced in 2004. No medical practitioner who examined Mr. Rimmer believes his current condition was caused by a single event, as opposed to cumulative trauma spanning that 23-year tenure. Again, I'll return to the Sellers case. It's similar to the current controversy. In that case, the employee was exposed to a noisy work environment starting in 1960. He sought treatment after one discrete episode of exposure to noise that caused pain in 1965. But he returned to that noisy work environment until 1974. And defendants in that case basically made the same argument the defendants in this case are trying to make, that the clock should have started running based on that discrete episode in 1965. This court rejected that and said, timeliness is assessed by reference to the diagnosis with the occupational disease, not that discrete 1965 episode, as the medical testimony in that case established that exposure to heightened levels of noise prior to 1975, cumulative trauma, the same thing that we're dealing with here, caused Mr. Sellers' disability. In closing, because Mr. Rimmer provided timely notice of his occupational disease, the full commission's opinion must be reversed, in this case allowed to proceed to the merits. At the very least, this court must remand to the full commission so it can grapple with the fact that defendants had notice of all of Mr. Rimmer's 2002 to 2004 medical treatment. Thank you.
Thank you. Good afternoon. Are you ready to proceed?
We're ready. May it please the court, my name is Lindsay Underwood. I'm here today with my co-counsel, Dale Flamia. We are both with the Raleigh office of T. Campbell, and we are here today representing defendant Appalese, the town of Chapel Hill, and the North Carolina League of Municipalities. Your Honors, I'd like to first make a very important distinction between the two statutory issues that we're dealing with here today. And I think Judge Collins's question goes directly to that. We have two separate, both a notice requirement and a requirement that exist in the workers' compensation system when it comes to occupational diseases. Our argument here today is that neither of those are met. The first is the 9722 notice requirement, and the second is the 9758 filing requirement that we have that has the two parts, both B and C. It's important to note that these statutory requirements are extremely generous to injured workers in North Carolina, essentially giving the claimant the later of the two statutory periods to when the statute starts running to either provide notice or file the claim.
Now, Ms. Underwood, is it your client's position that if someone suffers from PTSD that exacerbates over time, that they are required, in order to have compensation, to file at the initial time that they could have ever, that the first injury they had that started this process? Is that your client's position?
No, Your Honor. Our client's position is that the appellant or claimant in any case should file their claim when either of the two statutory provisions of 9758 are met. So either
Isn't that exact? But when you say that, isn't that in essence what you're saying is exactly what I'm asking you if it's not your position?
No, Your Honor. The position is that either when he receives competent medical opinion indicating that he has a work-related condition, or if it's later he sustains a disability related to that condition, whichever one of those are met at the later date, that is when the claimant has the statutory time start running to file the claim. So it's not the first exposure, and in this case it's not the first exposure. We have even
The commission found that he was initially diagnosed with PTSD in 2004. Can you point me in the record where the evidence he was diagnosed with PTSD, not concussive, but PTSD in 2004?
Yes, Your Honor. If we look to Dr. Benjamin's February 5th, 2004 record, he indicates that Mr. Rimmer was diagnosed with resultant PTSD, depression, and anxiety. That's clearly stated in the record, and I think what we also need to note is that the totality of the record indicates here that the very latest that Mr. Rimmer had noticed that he had PTSD related to his work with the town was that February 5th, 2004 date. Even if we're looking at that most later date, we would argue, and per Mr. Rimmer's own testimony, that he knew he had some conditions in 1996. He received treatment for that from the EAP. He reported when he first presented to Dr. Herfkens in January of 2004 that he had a history of PTSD related to his work as a firefighter. And then that was indicated in both Dr. Herfkens' note and Dr. Benjamin's note.
Well, do you agree, though, that there's a difference between PTSD symptoms or subclinical PTSD and a full PTSD diagnosis?
Your Honor, we would have two different issues with that. The first being that I think Dr. Benjamin's note does clearly state that he has resultant PTSD. His note doesn't indicate that he has resultant PTSD symptoms. He just indicates that he has PTSD. And there's been no allegation in this case that Dr. Benjamin is for some reason not a competent medical authority on this issue. So we would contend, first off, that very clearly in the records.
Is that in the record itself, or is that in a deposition? Where is Dr. Benjamin?
That's in the record itself. Dr. Benjamin and Dr. Herfkens did not testify in this case. However, their records were stipulated too. We would actually contend that the fact that they were not called by appellants does indicate that those records continue to speak for themselves, and appellees have no issues with the statements in those records, which are stipulated part of our evidentiary record at this time.
So where is it in the record again?
Yes, it's in Dr. Benjamin's record, which is found in the exhibits at page 209. I think what's also important to note is by the time Mr. Rimmer began again alleging that he was experiencing those same PTSD symptoms and the PTSD that he had back in 2004.
Did he say the same? They were the same he had in 2004?
I believe they are similar symptoms when we look at the record, Your Honor. He continues to report insomnia, nightmares, headaches, the same things that he did indicate he was dealing with back in 2002 and 2004. And when he presents to Dr. Sue and Mr. Allen, who ended up taking over his care in 2017, he also reports to them, I have a history of PTSD related to my work of being a firefighter.
Can I ask you, would an employee's self-report ever be competent to support benefits?
We think it would, Your Honor.
So they could say, as soon as they say, I have PTSD, then that's sufficient?
Well, we think it would be sufficient in line with the totality of the evidence here.
So not by itself?
Which also includes the evidence that both Dr. Benjamin and Dr. Herfkens assessed the PTSD.
But my question is solely, is an employee's self-report of a diagnosis sufficient on its own?
No, Your Honor. It is not sufficient under our workers' compensation system. Our courts have held that a claimant cannot diagnose themselves, but I think the important thing to note here is that he didn't have to diagnose himself. We have both Dr. Benjamin and Dr. Herfkens providing the diagnosis, and we have Dr. Sue, when she completes his retirement disability paperwork, most recently in 2017, indicating that yes, he had a diagnosis in 2002 and that he was well aware of the same, as well as Mr. Rimmer's own testimony under oath at the hearing of this matter, in which he stated, I am aware of my PTSD diagnosis, and I recall that Dr. Benjamin provided that notice to me.
I want to ask a question. So let's assume that he was diagnosed with PTSD. He didn't miss any work for it, correct, at that point in 2004?
We would contend that he did miss work in 2003 for the concussive symptom and resultant PTSD. This is all related to the initial disability that he had had a year prior. And under 9758...
Now, is there anything in the record that says that he's being paid disability for PTSD?
It's not explicitly in the record, Your Honor.
Doesn't the record really talk about his shoulder injury and those kinds of things as to why his disability is being paid?
We actually don't have any evidence in the record to indicate that this wasn't also for those lingering post-concussive symptoms.
But it doesn't mention it, does it?
It does not explicitly say it in the record.
And it doesn't implicitly say it either, does it?
No, it does not. But I think if we take the totality of what Mr. Rimmer was dealing with at that time and what he continued to report when he sought treatment in early 2004, which there's no indication in the record that he was continuing to treat for his shoulder at that time, all of his physicians agree that he was still dealing with those symptoms related to post-concussive disorder, PTSD, anxiety, and depression. Under 9758, it doesn't have to happen in the order that he receives a diagnosis and then is out of work. It's the later of those two items which indicates the statutory requirement for filing the claim. So once he received the official diagnosis, at the very latest, giving him the most benefit of the doubt on time, that would be the February 5th, 2004 date, at which time he had 2 years to file his claim.
But you don't have to file a claim if you don't want benefits for that specific injury, correct?
You do not have to file a claim, however, that is our statutory requirement.
So if you don't want benefits for that specific injury, you can continue to work because you're actually going to make more money than if you took benefits, correct?
That's
So if
correct.
he doesn't file a claim, and then he is back at work until 2017. So at some point, that injury was over. He worked for 12 years, no symptoms. Don't we have a new injury?
Your Honor, I don't believe we do, and I don't believe the record supports that. I think what we do know is that all of the cumulative trauma that Mr. Rimmer described in his testimony, it essentially ends at 2009. He moved to a more administrative fire marshal position in 2012. So at the very latest, if he would have sought treatment in 2009, he may have had a better leg to stand on to say, now I have a new claim. But again,
So are you saying all the reports of people who have things that say happened to them in Vietnam, and they come out of Vietnam, they're fine, they work, they have a career, and then they get older, they get under some other stress, and then they start having flashbacks to things that happened in Vietnam? Is it your contention that that is not PTSD?
Your Honor, it would be my contention that that would be PTSD, depending on what the medical providers under that example would state, but there's no statutory requirement for a veteran to seek benefits at a VA hospital. We have these generous time limitations to essentially give the employer the ability to investigate the claim, provide treatment, and ultimately even know that a claim exists, which in this case wasn't done. Again, I think there's a question as to whether if appellant would have brought this claim 30 years down the road, would we contend that that's reasonable? Everything kind of stems from this initial treatment, this initial diagnosis.
Can't there be delayed onset?
There can, Your Honor, but I don't believe
Because
that's...
it sounded like what you were saying is, well, if the incident, if he hasn't been in any of these traumatic situations since 2009, then his PTSD could not have occurred any later than 2009.
Your Honor, what I will say is that the 9758 requirements do not allow for a late reporting, even in the or a late filing, even in the circumstance where there's a late onset, where there is a diagnosis from a competent authority, which in this case we have, as well as a related disability.
So what
back in
you're really
2003.
saying, pardon me, I'm sorry.
No, my apologies.
What you're really saying, I think goes back to what I was asking you, is that you're saying it doesn't, that if you've got cumulative over time and that's what adds up, it's your client's position that if you didn't do something back here, that you've waived your right, even though it's there are cumulative events, and those cumulative events add up to, at the end, a disability. Your client is saying if you don't file it back here, that you've waived that right. Isn't that right?
In the event that, as it is in this case, the cumulative exposures that are particularly being cited and testified to ended in 2004, at the very latest, 2009. What we're talking about now is a 2018 claim that was filed trying to date back to those incidents and injuries, where our statement here today is that appellant knew about his PTSD diagnosis. He himself has dated it back to at least 2002, at the very latest 2004. He knew he had PTSD. He's told the physician he has, and he has it reflected on his retirement paperwork that that is the case. And he is alleging those cumulative exposures, which for most purposes in 2004, I think if we look at the record, we can see cited 1996 fires, 1998, incidents that occurred in 2000 and 2001. There's very little in the record to support that now that we've gotten through this accumulation and it's kind of resulted at the end here at a 2018 date, that's the result now of the cumulative exposure catching up to him.
So is it your contention that if your last exposure to asbestos or something was in 2009, but you weren't disabled until 2017 or 18, you could not file a claim?
No, Honor, you could file a claim. However, we're contending in this case that their disability and the diagnoses were already met by the time the 2004 date came around.
That he was already dead by 2004.
That's correct, Your Honor. He had had the disability in 2003 resulting from the post-concussive symptoms, the PTSD, the anxiety, and depression.
Then how was he able to work for 13 years if he was disabled from this?
Your Honor, it doesn't require a continued period of disability. It just requires that there be evidence of disability. A claimant doesn't have to be out of work the entirety of the time to show that there was a disability. Even if the claimant was out of work for, let's say, 7 days around that time for that issue, that would indicate that that disability prong under 9758B, C, my apologies, was met. And essentially the claimant would have from the later of those 2 dates. For example,
I want to ask a quick question. A jurisdictional fact in this case, plaintiff is arguing that whether notice was timely filed is jurisdictional, so we look at it de novo. Is that correct?
That is correct, Your Honor. 9758 concerns a jurisdictional fact. And I think another important statutory issue that we should also note is jurisdictional is 9747, which is also a condition precedent. Appellant is arguing today that that was a new issue that was raised by defendants. However, just like issues regarding 9758, issues of jurisdiction can be raised at any time, even before the court. And if the argument is that appellees had notice of this issue and had notice of all of this treatment back in 2004 because there was a nurse case manager involved for the 2002 claim, then this claim is clearly statutorily barred under 9747. Under that statutory requirement, the claimant would have had 2 years after the date the Form 21 was approved to allege a change in condition. And that was never done in this case either. But I think what's also important to note is that some of the provisions under 9722 have been argued by appellant in this case to apply to 9758. And those are 2 separate arguments, both a notice argument and a timely filing argument. Under 9722, that's the only area that things like reasonable excuse and prejudice come up. There is no excuse provision or prejudice to the employer argument that arises under 9758. So I do just want to note that we continue to contend that even if we were to not be successful in defending this claim under 9722, 9758 does not contain those same issues regarding reasonable excuse or prejudice to the employer. There is no such exception allowed.
Well, what is a latent onset of PTSD?
Your Honor, I believe that would be if, for example, if Mr. Rimmer in this case had never experienced any symptomology whatsoever and had never received a diagnosis, and then just in 2018 had begun feeling those effects and obtaining those symptoms. That would, of course, be a latent onset of PTSD, and in that case, there would have never been any diagnosis or notice to the claimant. In this case, that's not what we're dealing with here. We have an onset of PTSD, and now we have essentially what is kind of being argued as a reemergence of a PTSD, which our courts have continued to hold that you only have one claim stemming from the conditions affecting the same body part, which is what we would have in this case.
So if you break your arm heals, you can't file for another claim if you break your arm again?
You can, Your Honor, but that would be under an injury by accident standard.
Okay. And so explain to me the difference between those 2.
Yes, Your Honor. So, for example, if we look at the Johnson versus Duke University case, which came out in 2010, that case essentially dealt with an occupational disease repetitive motion case to the foot. What happened in that case is the claimant sustained an injury to his foot over a period of time of working. He sought treatment for that claim. He ultimately filed that claim and tried to turn around and argue, well, every single day that I had to return to work was another claim, essentially, on my foot because I continued to have that exposure. What our court said at that time was that that would end up, first off, as being incredibly inefficient for our judicial system because we would essentially have a new claim being filed for every single day that a claimant continued to work. What they also said was that that exact condition that he was complaining of was part and parcel to the initial claim and that it did not create an entirely new cause of action to file that new claim.
So it's not that you could never recover from an occupational disease. It was just that in Johnson, he hadn't recovered. Is that correct?
I think that's correct, Your Honor. And at the time, he, yes, that's correct. He had not recovered.
So you could recover from an occupational disease and years down the road, file a claim for that same disease.
I think that could be possible, Your Honor. I think if, in this case, if, for example, Mr. Rimmer had filed a PTSD claim back in 2004 when he received that diagnosis and had eventually, for example, settled that claim and continued to work with the town, and then 10 years later, after other exposures or maybe some other one traumatic incident, had again been diagnosed with PTSD, that could create that circumstance. However, I still think there would be a fair argument to make that that claim was closed at the time that it was resolved if the symptomology and causes were the exact same. I think it would significantly depend on what the medical experts would have to say about it in that case. But I think what's important to note here as well, when it comes to the diagnosis at least, is that Mr. Rimmer continued to present to his new physicians, Mr. Allen and Dr. Sue in this case in 2017, and reported a very long history of PTSD that he was aware of related to his work as a firefighter. During their depositions, Mr. Allen testified, "It was my understanding he had PTSD due to his work back in 2002 when he was 35 years old." Dr. Sue testified similarly. "Yes, I was aware that he had a long history of PTSD dating back to 2002 and noted the same on the paperwork that she filled out regarding his retirement disability status." Just to kind of discuss a little bit more the 9722 arguments in this case concerning notice. Obviously, our full commission found that notice was not properly established in this case and that appellant did not meet his burden to show that notice was given within the 30-day statutory period, and we would continue to argue that that's the case. We only get to the argument of reasonable excuse if it's determined that there was no actual notice or written notice provided in the 30 days. One of the things I wanted to note is that appellant has argued that the appellees had significant notice or actual notice of this condition due to the nurse case manager that was involved in the 2002 claim. I would note first off that the correspondence from the nurse case manager, which is the first evidence we have that there was any knowledge on the part of defendants that this treatment was even being sought, was a letter from the nurse case manager to opposing counsel at the time, who's not the same that we have in this case, and essentially said, "We've been made aware that there has been a request for treatment in this case regarding neurocognitive issues. Can you please send us those records?" That record was first dated May 10th of 2004, so even if we take that date, that's at least a 90-day delay, which is outside of the notice requirements. So we would still argue that's not sufficient. But even so, we would argue there is, of course, extreme prejudice to defendants in not getting any notice at that time of these conditions. What appellant has cited here today is that they essentially got the benefit of work and that appellants have pointed to the lack of treatment that was provided during those 13 years. And we would continue to argue that the record very much establishes that there is this 13-year gap in treatment, and Mr. Rimmer himself testified that his mental health treatment is helpful to him. He believes that receiving ongoing therapy is useful, and that his medication use has also helped him in his recovery. So to turn around and state that there's no evidence that this would have helped him all of these years is completely incongruous with what Mr. Rimmer himself testified. The other statements that were made here today was that there's no evidence there was any job that Mr. Rimmer possibly could have done. But what we know from the record in this case is that Mr. Rimmer himself moved to a different job in 2012. He didn't inform his higher-ups that it was due to his mental health issues, but he essentially requested a transfer to a more administrative position. So what we know from this record, based on Mr. Rimmer's own testimony, and what actually happened in the case, is that there was a job available that was more administrative in nature, that he was qualified for, and that the town was happy to place him in. So the combination of all of that indicates that had this claim been reported in 2004 properly with written notice to advisors, or a claim would have been filed, we could have, of course, moved Mr. Rimmer out of that position, and that's just based on his own testimony.
Can you just remind me, how long was he with the police department altogether? Sorry, with the department.
I believe that was 25 years.
And is he unable to work at all at this point?
We would contend that there is an argument that he's not fully disabled. That's not an issue that made it up to.
Okay, so right
this
now,
level.
we're not even at the merits, so.
That's
Okay.
correct, but we would contend that there's evidence in the record as a whole to support that he is capable of working in other. I believe his medical providers have testified that he may not return to the fire department, but that there are other positions that he could certainly work in outside of that arena of work. The other thing I wanted to note in this case is that under the Dowdy versus Fieldcrest Mills case, when we're talking about diagnosis, for example, something like PTSD symptoms versus just PTSD, we of course contend that there was a clear and concise diagnosis of PTSD, but even if we are able to state that there's PTSD symptoms, this is supported by the Dowdy versus Fieldcrest Mills case. In that case, the claimant was told he had bisonosis initially. Later, it was determined that he had COPD, and essentially he argued that while the bisonosis diagnosis wasn't actually correct, we should go by the COPD diagnosis. What this court held was that he was informed of the nature of his condition and the work-related nature of it, even when he received the bisonosis diagnosis. So that actually did not stop the statute from running, and did not reset it or give him additional time to file that claim. He should have filed it when he had that initial notice. So in closing, Your Honors, I would contend that claimant cannot meet any of the statutory requirements that were provided in the Workers' Compensation Act for occupational disease. First, he failed to provide notice under 9722. Secondly, he failed to file a PTSD claim under 9758. And finally, if the contention in this case is that it was all related to this 2002 claim, and thus appellees should have had notice of it, then it's of course barred by 9747, as there was never a change of condition alleged. At this time, I would yield the rest of my time for questions. Thank you, Your Honors. We would request that the full commission's findings and holding in this case be upheld.
Thank you.
Thank you.
Proceed with your rebuttal, please.
Thank you, Judge Zachary. A number of points that I want to make here. Judge Collins, I first want to return to a conversation that we were having in regards to notice and filing requirements. When there's an occupational disease, you have an obligation to provide notice in a timely fashion within 30 days, unless there is notice that is somehow provided in a different fashion. The employer is somehow aware of it. The filing requirement, however, that you were asking about, 758C, is different. What triggers the filing requirement is not only notice, but is also disability. And to Judge Arrowwood's argument, I do not understand the defendant's argument that there was disability in 2004 in this case. Disability in the Workers' Compensation Act is assessed by whether you can work. Finding of fact 4 from the full commission, which is unchallenged by the defendants. Defendants accepted plaintiff's 2002 claim as compensable for his neck on a Form 60. Plaintiff's primary physical injury was to his left brachial nerve. Later, plaintiff was entirely out of work from 10 December 2002 to 31 March 2003, and then worked light duty from April 2003 through 17 July 2003. On 18 July 2003, plaintiff returned to full duty in his regular job with no restrictions. He was back at work on July 18th, 2003. He was out of work before that, disabled due to this left brachial nerve issue, the physical issue.
Mr. Brooke, how do you address the appellee's argument that Dr. Benjamin's note of February of 2004 was a PTSD diagnosis?
Well, first, it is an equivocal note that talks about PTSD symptoms. It also talks about resultant PTSD. What did that resultant PTSD symptoms, what did that PTSD result from? An injury by accident in 2000, those PTSD symptoms result from an injury by accident in 2002, which disappears from these references to symptoms, disappear from the records in March of 2003. Everyone agrees that what he's suffering from now is an occupational disease that is based on cumulative trauma. Also, it bears mentioning that Dr. Benjamin is Mr. Rimmer's primary care physician at that point. He referred Mr. Rimmer to Dr. Herfkens for neurocognitive evaluation. And that note from Dr. Benjamin is plainly a derivative note pointing back to Dr. Herfkens' note from the month prior. It says, please refer to Dr. Herfkens' note of January 6, 2004. And Dr. Herfkens' note says, it is also possible that plaintiff has mild residual depressive and PTSD symptoms as a result of this accident. That underlines all the points that I've been making about how different this is in 2004 from right now. Possible. Nobody's talking about whether it's possible whether he has PTSD right now. It's plain he has full-blown PTSD. Mild. What he is dealing with now is plainly not mild. PTSD symptoms. Symptoms are, as Dr. Artigue, again, the defendant's expert, talked about, not indicative of having a diagnosis.
One could have flu-like symptoms and not have the flu, or COVID symptoms and not have COVID.
Precisely. You could have, and Singleton says, evidence of a dust disease does not constitute a diagnosis with a dust disease from the North Carolina Supreme Court. You can say that you have symptoms consistent with COVID-19. That could just mean that you have a fever. That doesn't mean you have a COVID-19 diagnosis. It certainly doesn't mean, if I'm told that I have COVID-19 symptoms, that's one thing. I'm not happy about that. If I'm told that I have COVID-19, that is a consequentially worse thing that has been, and the severity of which has been conveyed to me. So they're entirely materially different. It also bears mentioning here that this idea that the symptoms were the same in 2004 and 2017 is just not the case. He was vomiting day in, day out upon arriving at work. He was having intrusive thoughts from things that he had seen on the job. He began experiencing near nightly nightmares. It's not the insomnia related to discrete events he had previously. It's not the insomnia based on weird work hours that he had previously. This is nightmares where he's terrified of going to sleep for what he's going to see when he goes to sleep. Defendant's own brief talks about how he started experiencing unusual symptoms in 2017.
I'm so sorry, I'm going to cut you off. I just want to get to this point. So when we talk about jurisdictional facts, and you both agree that these are jurisdictional facts when we're talking about filing of notice, or filing notice, right? Does that mean that every single finding in the full commission's order is de novo, or are some of those any competent evidence to support and are others de novo?
Anything related to whether there was a diagnosis that triggers the notice requirements is a jurisdictional fact that is reviewed de novo. Anything that relates to whether facts related to whether there was a timely filing is de novo. The general rule applies in regards to a number of other facts, but this case hinges on whether there was a diagnosis that triggered the notice requirements in large part, and as a totally hinge, but in large part, turns on that, and that is a jurisdictional.
So we look at it de novo, but
Yes.
what quantum of evidence is needed to support it?
Support the findings that are made by the full commission. I believe based on de novo review, those findings don't get any deference. You look at the
We
full
just look
record,
full record.
and you, and the Cunningham case from this court, the McGuine case from this court, both from 2020 or workers' compensation cases that talk about how we do de novo review, and you even do credibility determinations, and that's what the case law says. And that might seem a little bit counterintuitive, but the case law is very, very clear that those jurisdictional facts are reviewed de novo, and that the full commission's findings on point are not accorded any deference. I want to also deal with the idea that the cumulative exposure ended in 2009. Again, that's not the case. He continued to report to fires well after 2009. Again, there's this 2017 episode where he responds to a fire where dogs are incinerated. That shortly thereafter, he starts vomiting the day after he returns to work. Defendants' arguments that to the extent that I understood it, is that their nurse case manager received these notes on some sort of lag, and therefore extreme prejudice followed because they could not direct the medical treatment because of a 90-day lag. The only evidence that's cited in support of that seems to be Mr. Rimmer stating that his 2017 psychological treatment has been helpful to him. That's just indicative, again, of the fact that they're relying almost exclusively on his self-reporting, which the case law tells us is of no moment when we're assessing whether there has been a diagnosis and when we're assessing these sorts of prejudice issues. I'll also note that the Jones case has never been responded to by the defendants. The Jones case reversed a full commission ruling, found that it was an abuse of discretion because that dealt with reasonable excuse, which is assessed for abuse of discretion, and said that the defendant's failure to report an injury until he understood the severity of it, when he did report it, when he understood the severity, reasonably excused the failure to report it when he originally recognized that. They don't respond to that in the briefing that they filed in this court, and they've not referenced it in front of this court. That establishes that, that there is a reasonable excuse. I'll close very briefly just by turning to the PBA's amicus brief in this instance. And they highlight that first responders, as Judge Zachary was driving at, like firefighters, face cumulative trauma over the course of their careers. That trauma can catch up to them over time. This is something that Dr. Artigue and Dr. Sue agreed on, that you can have latent onset of these symptoms, and it can cut short a productive career. And they also highlight, very importantly, that the case law is clear. We give a liberal construction to the Workers' Compensation Act, so we don't deny benefits based on strict, narrow, or hyper-technical arguments. In this case, it's very clear that what Mr. Rimmer is going through now is different than his 2004 circumstances. As soon as he recognized that, he told his superiors, he filed a claim, and therefore the full commission's opinion should be reversed. Thank you.
Thank you. Do you have any further questions? Any further questions? Thank you very much. That concludes oral argument in this matter. I want to thank both of you for your excellent arguments. Mr. Soar, we'll take a break now.
This session of the North Carolina Court of Appeals is adjourned.